Please be seated. All right, members of the jury, you submitted 2 questions for me. The first question is, if the jury cannot reach consensus, what is the guidance around how long and what steps should be taken? And the answer is, I'm going to reread to you an instruction that I previously gave you. You should discuss the case with one another and deliberate with a view toward reaching agreement if you can do so without violating your individual judgment. You should decide the case for yourself, but only after you have discussed the case with your fellow jurors and have carefully considered their views. You should not hesitate to re-examine your views and change your opinion if you become convinced they are erroneous. But you should not surrender your honest opinion simply because other jurors disagree or merely to reach a verdict. Your second question was, can the zip ties be removed from Exhibit 199, Potter's gun, so that it can be held out of the evidence box? And the answer is yes. When you go back into the deliberation room, you should knock on the door and hand the deputy the gun in the box. The deputy will then remove the zip ties, and he will knock on the door and give the gun to you. After you're done with whatever you want to do with the gun, you are to knock on the door again and hand the gun to the deputy. And according to our protocol, it will have to be zip-tied in the box again. To let you know, the gun is not loaded. It's fully secured. But we do have to keep it in the zip tie after you're done with it. Now, the questions were submitted at 4:00 p.m. on 12/21 and signed by the jury foreperson. So, okay, members of the jury, please go back into your deliberation room and knock on the door and hand the box to the deputy that will be waiting outside of your door, okay? Thank you.
To removing the gun from the case, it should remain in the case for safety purposes. And we do take issue with your ruling on that regard as well.
Okay. Mr. Frank?
Thank you, Your Honor. If it's all right if I remain seated.
Yes.
Microphone. Your Honor, with regard to the first question, we pointed out to the court State versus Martin, 211 Northwest 2nd, 765, Minnesota Supreme Court case from 1973, in which the Supreme Court really disposed of the previous version of the so-called Allen charge in favor of what was then the ABA standard for this situation. And that ABA standard has basically been adopted into jury instruction 3.04. Jury instruction 3.04 contains the paragraph that the court just read to the jurors and which was in the court's initial instructions to the jury. So this is the process that you followed today that was approved of by State versus Martin, which is still good law. Because the court had given them this instruction to begin with, it was appropriate to give it to them again in response to this question. If any concern about calling out that instruction is certainly not prejudicial in any way, basically answers their question for them in a very even-handed and long approved of manner going back to 1973. With regard to the second question, Your Honor, we know there is no ammunition in the jury room. We know that there will still be a essentially a lock on the gun that couldn't be fired anyway. And so the zip ties that are being removed are what secure it to the box that has the exhibit sticker on it. So we were fine with the court doing exactly what you've instructed them to do. The other concern, of course, always is having contact with the jurors. We understand that the court has instructed the deputy to not talk about the case at all with them, and knowing that should there be any conversation that could be brought to the court's attention. So we agree with the court's process of handling both questions.
And of course, the objections of the defense are overruled.
Back in 1973, up until about 1980, the judge did not give instructions to the jurors. They had them. Well, that's why we objected. They already have that instruction. It's in their instructions. So there was no reason to read it. Just tell them to look at their instructions. That's what's usually done, and I've practiced.
Okay. And I've overruled those objections. Okay, is there anything else we need to put on the record? Okay, thank you, counsel.